Good morning, coffee drinkers. I'm Hallie Zobel. I'm an attorney here at Private Corporate Counsel. And on today's Law Moment, we have the privilege of a guest by the name of Scott Tufts. Scott Tufts is here at Private Corporate Counsel, and he has quite the pedigree. He graduated from law school at Wake Forest University in North Carolina, and he also obtained his tax degree from University of Miami in LLM. And this morning, we want to thank you, Scott, for stopping by our Law Moment and talk to us a little bit about a case that's piqued your interest. The case has to do with, happened 2 years ago, went up through the appellate court in the 4th DCA. But before we get started on that, the lesson we're going to be discussing this morning is operating agreements versus wills, and what's the best way to wrap those together and do a real solid plan for those of you who own businesses. So, Scott, thank you so much for showing up this morning.
Thanks for having me.
And tell me a little bit about what you want to talk about this morning.
Yeah, so each of us have our respective kind of specialties or things that we focus on. And it's kind of interesting how things aren't so simple in life, right? So if I've been a tax lawyer for over 30 years, and part of that tax training brought me into the world of LLCs because they started in, I'm going to age myself, but they started in full, fervor in the early 90s because in 1995, the IRS decided that they would simplify how they would be taxed under the federal tax law to check the box. They exploded in popularity because there was certainty with what the LLC could be taxed as. So a tax lawyer like me would have to get to know LLCs pretty well and how to draft them and what to look for. A lot of times folks will wonder why they're 40 some pages and they have lots of tax provisions in them. So someone like me would be a natural. But what people don't also know, early in my career, I did some estate planning at the same time with business planning. And then there are business planning issues and succession planning issues and estate planning issues that come up with a business, with the interests and understanding that. So it's been pretty interesting. So the chance to come on the show and talk about this case or LLCs is certainly something I'm comfortable doing and I look forward to.
Well, as an estate planning attorney, I get asked quite frequently, what is an LLC and how does that operate? And should I have one for my business? Would you tell our viewers what an LLC is?
Sure. It's a limited liability company. Some years back, they thought they would combine it's kind of like metrics and inches. They thought they would come along and make a hybrid, something that took the best of partnerships and corporations and kind of come up with a new entity that had the best of all worlds. But like with everything, LLCs are flexible. You can have a member-managed LLC, a manager-managed LLC. It could operate more like a general partnership, or it can operate more like a limited partnership with centralized management, but with liability protection. Because what folks need to understand is that they have, it's kind of like, I call it rooftop and underneath protection, but LLCs offer a full range of liability protection, much better than corporations. And then tax-wise, you can elect your way into different types of treatment. So people don't realize it, but you can be an LLC, but for federal tax purposes, an S corporation.
So do you see them gaining in popularity, and do you draft these for your clients?
Yes, so absolutely. So they start like corporations in the sense that you have articles of organization, not incorporation. So you get started with the state, but you have to have an internal document called an operating agreement. And that operating agreement is to cover the soup to nuts, operations, who's going to be an owner, how what's going to happen, how you're going to run management, almost anything you can think of. And yes, I draft those for my business clients and also deal with the litigation that's over them. So I'm on both sides. I'm I'm on the assembly line, and then when the wheels fall off, I'm there too. Hopefully not of the ones I put together.
Absolutely. So do you see, does your clients need a will, a last will and testament, if they've developed an operating agreement for their business? And is there a necessity for that also?
Yeah, absolutely. So the operating agreement can cover and start to encroach upon, and we know this from the case, can start to encroach upon the desires of the owners as to what should happen at death or disability. It's prudent in an operating agreement to try and address those issues, but it's also a private matter, right? And what you're going to do with your interest, is that something you should share with your business partners? Maybe not. Maybe it's more private. So the tension between what you're specifying in an operating agreement as to what's going to happen might have a different motivation than something as private and personal as a will, where that's, or even a revocable trust if you're trying to avoid probate.
So really, it seems like it would be best to have both of those, is what you're saying. Let's talk about a matter that came out of South Florida, the 4th District. And there was a gentleman who owned a business, and I believe several of his kids, not all of them, were involved in the business. And I'm referring to the Tita versus Tita matter.
Right.
And went up to the appellate courts. And in that case, did the decedent have a plan for where he wanted his shares of his membership to go to through his will?
Yeah. So the issue there was the tension between what he had put forth in a will and what the operating agreement had said, and whether they could be read harmoniously or whether they were contradictory.
And I bet you from reading this case, you see this a lot in litigation, where his desires were necessarily, it seemed from my reading of the case, he wanted these 2 children to receive the benefits of it, but not necessarily his wife, who he had provided for by other ways. Do you see that from time to time?
Oh, of course. And this can happen within a family dynamic. You have some that are dedicated to the business, some are not. Some are more, might have a talent for the business. Some may not. Some may be far away and can't attend to the business. All kinds of different permutations. So the question for family businesses oftentimes is, what is going to happen if the patriarch or matriarch go down or become disabled? Is there a family member to step in and continue the business? So certainly this is understood. And then the question of is it going to be an economic issue, right? Is it really just to make sure that the interest is passed on where you want them to stay in the business, or you want to give them the opportunity, like a right of first refusal, or do you want to just make sure that the value, the money, that it's redeemed? In other words, that it's bought out and that the money goes to particular family members. Maybe some family members were involved in the business. So I think all these things play themselves out, and you can see that tension from the case because they make a big point to compare and contrast this case with another one called Bleckman that was focused on when there was a contradiction. And so the idea is that, I think in law, Hallie, we get to where we can't make knee-jerk, simple answers to our clients' questions. I think we're better off to say it depends, and they may get frustrated with that. But law is complex, tax is complex, these operating agreements are complex, and what matters are the words we use. Mm-hmm. And I think courts will try and I think if one thing I took from the case that I got the impression of from the appellate court and overall, they're going to try their hardest to construe both and read them in a harmonious way, meaning that they will presume that they meant both to be in play. They're not going to assume that there was a reason to be contradictory. I think that's what I took from it. So
to let our audience know this morning, he was very clear in his will, the gentleman who passed, that he wanted the shares of the operating agreement to specifically go to a son and a daughter.
That's correct.
Yet in the operating agreement, there was something called a death buyout. Would you tell our audience what a death buyout is?
Sure. So in an LLC operating agreement, we often will say that upon the death of a member, they're called members. So owners, they're not shareholders, they're called members. So in an operating agreement, we'll say that upon the death of a member, what's going to happen. And so we will talk through oftentimes a redemption opportunity, which means can the company come in with its funds or make arrangements to buy the interest out, right? And then how long will that process take? It's not going to happen instantaneously. There will be time to react and respond. So in this case, the question becomes the operating agreement itself will have a procedure in it to effectuate that buyout, or we'll talk about buying out the interest. Well, the question then goes is, if you're leaving the interest to the kids and then you have an operating agreement that talks about a buyout, is that contradictory? And the answer is not necessarily, because the interest at death may vest in their names, but the procedure takes time. And so that's
what's so interesting about this case. The clause said that the company could have up to 180 days, I believe it said, to elect through the operating agreement to elect. And through that clause, the estate, I believe it was the wife going against the son and daughter. Is that correct?
That's right. And so the wife takes issue with it. And the idea was that, well, they're inherently contradictory, so they should be ruled out, right?
Mm-hmm.
And so the question becomes, the death buyout provision said that upon the death of any member of the company, at its option, by providing written notice to the estate, will have the opportunity to acquire and redeem the interest. Now, remember, cross purchase is when a member buys another member's interest out.
Correct.
A redemption is the company coming down and taking that interest at an entity level. So, but it says at the option, right? May acquire the interest. So there's a difference between may and shall. Obviously,
Correct.
That can be written into an agreement.
And the company did notify the estate, and the personal representatives were the son and daughter, I believe.
Right.
And they did notify the estate, and the court made a big deal about that, saying, yes, that the will is controlling, because within the operating agreement language, they were to notify the estate.
Yep, absolutely. So it wasn't self-executing. It's kind
Correct.
of the right terminology. So you're exactly right, Hallie. So what we do in these agreements is we want to be careful with the words we use. And here it was a notice provision that would be given to the estate of the option being exercised. And then the question is, what happened to the money, right? So where does the money go? And then what does that mean for the processing or probate, if you will, of the estate?
Yes, and the court was very clear that there was nothing in the operating agreement that operated to trump the will,
Mm-hmm.
and so, or that a transfer of the membership would occur outside of the will. And so the court, in essence, ruled for the two children. Is that correct?
That's right. And one of the keys there is to unpack this in a way that helps us understand the issues better. The one part that I read, and you probably would have a better comfort with it, is that this argument that the wife made that the device should fail, getting into, I think of like redemption and other things. But under what circumstances does a bequest get somehow destroyed because of actions taken outside of a will? Meaning, like, I leave you a car and I sell the car before I die. It's not like we go buy you another car. The car's gone.
Correct.
And it's done. You don't get to say, unless you put something in there, right? The value, you don't get the value of the car because it's gone, unless there's language to that effect. So I got that part of the opinion. I was, it was something I was struggling with. Like, when would that argument work? And they brought up the Florida statute 732.514, this vesting provision that I did not, I had not recalled familiarizing myself with. And I think I'd be curious from your vantage point, how does that play out, or how would that argument have worked? Because it didn't work for her, because the feeling was, well, I don't know that part of it. What was your take on that last part of the case?
Well, I think the will was very clear that the specific devise went to the children, and based on that, in conjunction with the operating agreement, the court was able to rule as it did. And the other cases it quoted, the facts were a little bit separate situation, distinguishing between a different type of gift.
Mm-hmm.
And based on the other cases, the court said, no, this one's very clear with a different set of facts that it did vest at the time he died, but the operating agreement, that the company can still notify the estate, and that would, in fact, that would not trump the will.
So I think, it gets me to this idea of the time limit, right? How long do you have to get this in place? When people die, there's usually grieving and there's time. What is your kind of approach to how quickly you can even know there's an operating agreement out there? Like, what are you trying to do in these situations?
Usually I can have a client gather up that information for me within the first 15, 30 days. They would know that their father operated a business and gather up those documents. And maybe the accountant would have those documents if the lawyer certainly didn't. And I liked the way this operating agreement had a timetable specifically as to when the estate was to be notified, 180 days. And that goes to getting to my point as we wrap up our conversation, Scott, that it's important to work these operating agreements in conjunction with your estate plan, whether it's your trust, whether it's your will. And that always great to put deadlines and language such as that, because that allows a time limit, which we obviously need. And in this operating agreement, it was well worded with that.
Yeah. The last comment I'll make is that I think one of the things when you're putting an operating agreement together is you're going through the hypotheticals. Okay, if this happens, how do we want it to best handle, right? If there's a disability, someone's on life support, how is the business going to keep going? Mm-hmm. So who's in management? How does that go? Who's in charge? So I think all that is just very important to walk through and make sure the operating agreement has addressed it, and then side by side that the estate planning documents are in harmony with that.
Absolutely. And work with your estate planner to draft those operating agreements, and stay away from the cookie cutter agreements as best you can, specifically as you want to be as detailed as possible in that operating agreement. And this gentleman was, and the court did uphold his testamentary intent. Mm-hmm. And every day of the week, the court's going to try to uphold the testamentary intent of the testator if the court can. Absolutely. Anything else you'd like to add? No, I just thank you for having me on the show, and look forward to having you on the podcast that I do, which is Tufts on Tax. We try and come at it from the other, a different angle. And so look forward to having you on there. Thank you so much, Scott. Once again, coffee drinkers, this has been Scott Tufts. You'll know him from his podcast called Tufts on Tax. He was my guest this morning here at Law Moment. I'm Hallie Zobel, an estate planning attorney at Private Corporate Counsel here in Orlando, Florida.